Daniel Ashford kept a photograph on his desk that no one ever asked about, slightly out of focus, taken at his law school graduation by someone who didn't know how to use a camera. In it, Daniel stood in a black robe and yellow sash outside the University of Chicago Law School, holding a diploma in both hands like a man who had just retrieved something dropped from a great height. He was alone in the photograph. His parents hadn't made the trip from Milford, Ohio. Gas money was what it was. He kept it not out of sentimentality, but as proof. Evidence that the ladder was real, that you could start at the bottom in a 2-bedroom house off Route 40 with a father whose back gave out at 53 and a mother who cleaned dental offices on weekends and climb rung on nothing but work and will. That story was in important ways true. It was also, in ways he hadn't yet examined, incomplete. He was 39, just made junior partner at Hartley, Crane & Voss, a real estate firm on North Wacker Drive, where the lobby cost more per square foot than his first apartment. His specialty was property transition law, a precise phrase for the legal machinery that turned buildings into different buildings. Tenant displacement, zoning appeals, acquisition filings. He was excellent. His excellence came from treating every problem as a system to be operated correctly. The law didn't care where you grew up. It only cared whether your citations were accurate. The Grayson case landed on his desk on a Monday in November. Meridian Capital Partners had purchased a 6-story residential building in Chicago's Bronzeville neighborhood for $11.4 million. A historic property that hadn't been updated since the Carter administration. The plan was conversion, gut, the interior, build 22 luxury units, price them at market rate, sell the package to an investment group within 2 years. 41 of the 43 original tenants had accepted buyout offers and moved on. One had accepted and already left. One had not accepted anything. 62 years in the same apartment, paying a price that hadn't meaningfully changed since the Johnson administration. The new owner had given her 90 days notice, more than required. She had not responded. 3 certified letters had been refused. A paralegal had visited twice and been told through a closed door that she was not leaving. Daniel reviewed the file in 40 minutes. Illinois law was unambiguous. The building's rent control protections had lapsed upon sale. Month-to-month tenancies could be terminated with 60 days written notice for the purpose of substantial renovation. The notice had been given. The timeline had passed. Eviction proceedings were not only legal, they were overdue. This was his first major case as junior partner. He was not going to lose it. He scheduled an in-person service visit for Wednesday afternoon because certified mail had been refused 3 times and the statute required personal service when written attempts failed. His assistant Paula looked at the address and then looked at him. "She's 100 years old, Daniel. The age of the defendant doesn't alter the service requirement." Paula said nothing else. But she printed the directions with larger font than she usually did, and he noticed, and he said nothing about it. He drove to Bronzeville on a cold Wednesday, late autumn sky, the color of old concrete. The building was red brick, 6 stories, with a carved stone lintel over the entrance that read, "The Langston, Est, 1921. There was a community bulletin board just inside the front door, and Daniel paused in front of it without meaning to. It was covered in flyers, notices, photographs. The texture of a building that still thought of itself as a community rather than a property. A flyer for a food pantry at a nearby church. A notice about a block association meeting. A child's drawing of a building labeled home in careful crayon letters. He looked at it for a moment longer than necessary, then took the stairs to the third floor. Apartment 3F was at the end of a hallway that smelled like old radiator heat and something. Baking, bread maybe, or something close to it. Daniel knocked. He had his briefcase in one hand and the envelope in the other. Estelle May Grayson was small, maybe 4 feet 11, dark-skinned, with white hair arranged in careful waves and posture, so upright it made Daniel stand a little straighter without deciding to. She wore a deep blue dress with a brooch at the collar, as though she had been expecting a visit worth dressing for. Her eyes, behind thin frame glasses, were alert in the particular way of people who have spent decades paying close attention to other people's faces. She looked at him, not at the envelope, at him. "You're from the development company," she said. It was not a question. "I'm an attorney representing Meridian Capital Partners, yes. My name is Daniel Ashford. I have papers I need to serve you regarding your tenancy, Miss Grayson." "Come in," she said, and stepped back from the door. He had trained himself not to look too closely at the interiors of the apartments he visited during eviction proceedings. Details made abstractions concrete, and concrete things were harder to file neatly into the legal machinery. But Estelle Grayson's apartment made professional detachment nearly impossible. The walls were covered with student work, not casually hung, carefully arranged, framed, each piece labeled in small, neat handwriting with a name and a year. Watercolor paintings, pencil drawings, book reports typed on manual typewriters and preserved behind glass. An oil painting, skilled enough to look almost professional, labeled Marcus D. 1991. Charcoal portraits, collages. A hand-lettered poem labeled Keisha T. 1978. The paper yellowed, but the frame spotless. 62 years of student work, covering every available surface, organized with the care of someone who believed that what her students made was worth keeping permanently. In the corner stood an upright piano, its surface holding more framed photographs. Children, teenagers, adults, families, graduations, weddings, military portraits, college acceptance letters preserved behind glass. Hundreds of faces, arranged not chronologically but in clusters, as though the people in the photographs belonged in conversation with each other. Daniel sat on the sofa she gestured toward. She sat across from him in a wingback chair and folded her hands in her lap. "How long did you teach?" he asked, and then regretted it immediately, because he hadn't come here to make conversation. 54 years, she said. DuSable High School, English and Literature. I started in 1962, the same year I moved into this apartment. I retired in 2016. She paused. I moved in so I could walk to school. I stayed because it became home. Daniel opened the envelope, set the eviction notice on the coffee table between them. "Miss Grayson, this document initiates formal eviction proceedings. You'll have an opportunity to contest it in housing court, and I'd encourage you to seek legal representation." The buyout offer from my client. $11,000, she said. "Yes, to leave a home I've lived in for 62 years. Oh, not angry, just precise. I understand this is difficult. Do you?" She tilted her head slightly, not hostile, genuinely curious. "Young man, who taught you?" The question stopped him. "I'm sorry? Who taught you? Who was the teacher who made you believe you were capable of something?" Daniel opened his mouth and then closed it. The question had touched something he hadn't expected, something just below the professional surface. He thought, briefly, of a woman named Mrs. Calloway, 6th grade, Milford Elementary. She had kept him after class once and told him that his essay on the American Revolution was the best she'd read from a student in 10 years. He had been 11. He had never forgotten it, though he had not thought about it in, he realized now, almost 2 decades. "I'm not here to discuss my background," he said. "No," Estelle agreed pleasantly, "but I asked anyway." She looked at the papers on the table without touching them. "You may go, Mr. Ashford. I'll be in touch with my response." He left the apartment with the paper served and a question lodged in his chest that he couldn't dislodge. In the elevator, he pulled out his phone and almost searched her name. Then he put the phone away. It didn't matter who she was. It only mattered what the law said. But in the lobby, he paused at the community bulletin board again. In the corner, almost covered by a food pantry flyer, was a photocopied newspaper article. He lifted the edge of the flyer to read the headline. "Southside teachers' former students now lead the city." Chicago Tribune, 2007. He let the flyer fall back over it, walked to his car, and drove to his office, where certainty was still possible and the law was still a clean, neutral thing. The eviction complaint was filed on Thursday morning. Daniel assigned the procedural work to a second-year associate and spent Friday preparing the summary judgment motion that would follow once Estelle inevitably failed to mount a defense. The motion practically wrote itself. He was finished by noon. On Monday, the case was assigned to a judge. His associate knocked on Daniel's door at 2 p.m. The Grayson case. It was assigned to Judge Wendell Obey in housing court. Okay. He's requested a full evidentiary hearing. Daniel looked up. For an eviction case? Full hearing. Witness testimony allowed. 3 hours scheduled. That was unusual. Evictions were resolved by summary judgment 90% of the time. A full hearing meant testimony, meant evidence, meant a judge who wanted to understand something beyond the 4 corners of the complaint. Daniel could not think of a single contested fact in this case. Estelle Grayson had not paid rent that reflected the current market. The lease was month to month. Notice had been given. The law was clear. "Pull Judge Obey's recent decisions," Daniel said, "and find out who's representing the defendant." The associate returned an hour later. "Opposing counsel is Renata Cross. She's a named partner at Cross, Ellison, and Marsh." He paused. "She's doing it pro bono." Renata Cross was not a housing attorney. She was a commercial litigator, the kind of lawyer who appeared in national news when corporations faced existential legal threats. She had no professional reason to take an eviction case. The only reason to take an eviction case, pro bono, was personal. Daniel spent that evening doing what he should have done the moment he took the case. He searched for Estelle May Grayson. The results were not what he expected. DuSable High School dedicates Grayson Hall in honor of longtime educator, Chicago Defender, 2009. Bronzeville Park renamed for retired teacher who served community 54 years, Chicago Tribune, 2017. Estelle Grayson Scholarship Fund surpasses $1 million in student awards, Southside Wheatley, 2021. He clicked through each article. He pulled up the 2007 Tribune article he'd seen partially in the lobby bulletin board. DuSable teachers, former students, now lead the city. The article listed former students who now held positions across Chicago's civic, legal, and political infrastructure: an alderman, a federal appellate judge, the city budget director, the superintendent of Chicago Public Schools, the Cook County Public Defender, a state senator. Written in 2007, 18 more years of former students rising since then. He made a list, searched every name, and worked until midnight. He had mapped 41 former students of Estelle May Grayson holding significant authority across Chicago. The current Illinois Attorney General, a Stell student in 1985, had said at her Park dedication, "Everything I understand about justice, I first learned in room 214. He understood, with the precision of a man trained to read systems, exactly what he had walked into. He called his managing partner, Gerald Hartley, the next morning. The Grayson case. I need to flag something. The tenant has extensive community connections. The hearing may be theatrical. Then manage the theater. Meridian needs this building cleared by spring. Don't lose this, Daniel." He hung up and stared at his list of 41 names. Somewhere behind it, the question Estelle had asked was still waiting, unmoved. "Who taught you?" Daniel arrived at the Cook County Housing Court at 8:20 a.m. 40 minutes before the hearing. He expected to be among the first people there. He was not. The hallway outside courtroom 6 was full, not overflowing. Full, the way a space gets full. When people arrive with intention rather than obligation. 60, 70 people, dressed formally, speaking in quiet clusters. Daniel passed through them without making eye contact, pushed open the courtroom door. The gallery was already half full. He took the plaintiff's table, set down his briefcase, and watched the room continue to fill. By 8:55, every seat in the gallery was taken, and people were standing along the back wall. Daniel counted approximately 160 people. For an eviction hearing in housing court, Estelle arrived through the side door at 8:58, moving slowly with a cane, accompanied by Renata Cross. She wore a dark burgundy suit and the same brooch Daniel had seen at her apartment. She sat at the defense table and looked at the gallery. All these people who had come, and her expression was not triumphant. It was grateful, in the quiet way of someone who is not surprised to be loved, but remains moved by the evidence of it. "All rise," the bailiff said. Judge Wendell Obie entered. He was 61, silver-haired, with a face that had been shaped by decades of listening to human difficulty without losing the capacity to be affected by it. He settled onto the bench, looked at the packed courtroom, and was still for a moment. "This is the matter of Meridian Capital Partners versus Estelle May Grayson," he said. "Before we proceed, I have a disclosure to make. I was a student of Ms. Grayson's at DuSable High School from 1978 to 1979. I want that on the record. Both counsel have been notified. Does either party wish to request my recusal?" Daniel could have. Judicial ethics existed for a reason. A judge who had been taught by the defendant carried a connection to her that was difficult to fully set aside. But requesting recusal would delay the case by weeks, require starting over with a new judge, and would tell Meridian, who was already anxious about the timeline, that Daniel had mishandled the approach. "No objection from the plaintiff, Your Honor," he said. "Renata Cross, no objection from the defense." Judge Obie nodded. "Let's proceed. Mr. Ashford, please present your case." Daniel stood and walked through it with the efficiency of a man who had built the argument to be bulletproof. Property deed, transfer of ownership, original lease terms, month-to-month status, written notice delivered 90 days prior, Illinois statute governing termination for substantial renovation, 3 certified mail refusals, personal service completed. He cited 4 precedent cases, each one clean, each one directly on point. He spoke for 11 minutes. Every word was accurate. Every citation was correct. When he sat down, Judge Obie looked at Renata Cross. "Miss Cross." Renata Cross stood. She was 53 years old and had the particular stillness of someone who had spent 3 decades learning to say exactly as much as necessary and nothing more. Your Honor, the defense does not dispute the facts as presented. We dispute whether eviction is the appropriate remedy. With the court's permission, I'd like to call witnesses to establish the full context of what this case represents. Objection, Daniel said. Character witnesses are irrelevant to the legal question before this court. The statute doesn't contain an exception for community service. I'll allow it, Judge Obi said. The law gives this court equitable discretion. I want a complete record. Ms. Cross, proceed. Renata called her first witness, Alderman Curtis Webb, 14th Ward. Webb took the stand. He was 54, with the steady bearing of a man who had spent his career making arguments in rooms that weren't always prepared to listen. He identified himself, gave his title. Mr. Webb, what is your relationship to Miss Grayson? She was my English teacher junior year at DuSable, 1983 to 1984. He paused. And she's the reason I'm sitting here and not somewhere considerably less comfortable. Can you explain? When I was 16, I got arrested for shoplifting. It was stupid. It was also, for my neighborhood at that time, a very common way to get a record that followed you forever. Miss Grayson found out. She came to the station voluntarily at 11 o'clock at night. She told the officer on duty that she was personally vouching for me, that she would take responsibility for my presence at school every day for the rest of the year. And she did. She checked in with me every single morning for 9 months. Webb looked at his hands. I didn't understand then what it cost her to do that, to put her professional reputation behind a kid she had no obligation to save. I understand it now. Daniel cross-examined briefly. Mr. Webb, your testimony is clearly sincere, but does it change the property law governing this eviction? No, Webb said quietly. It changes whether I can watch it happen without saying something. Renata called 5 more witnesses over the following hour. Dr. Sandra Okonkwo, Chicago's Superintendent of Public Schools, student 1988 to 1989. Estelle had written her college recommendation letters for 3 schools and paid the application fees from her own salary when Sandra's family couldn't. She was now running a school system that served 330,000 children. Public defender Marcus Del Rey, student 1991 to 1992, he had been failing every class the year his father was incarcerated. Estelle had arranged tutoring, connected his family to a legal aid organization, and kept him on track through a period that he described as simply as possible, the kind of year that usually ends a story instead of continuing it. Illinois State Representative Diane Fong, student 1995 to 1996, Estelle had been the first adult to tell her that being an immigrant's daughter in a public school in Chicago didn't mean she was starting from behind. It meant she had already survived more than most people twice her age. That was a sentence I needed at 15, Diane said. I've repeated it in different forms at least 10,000 times since. Fire Captain Reginald Brown, student 1979 to 1980. Estelle had caught him sleeping in the school library for 3 consecutive mornings when he was 17, had quietly deduced that his home situation was untenable and had arranged for him to stay with the church family for 6 weeks without involving the school administration in a way that would have gone on his record. I asked her once why she did it without reporting it, Brown said. She told me some fires you smother quietly and some you let the whole building know about. She said she knew the difference. The final witness was Dr. Paulette Marsh, a research biochemist at the University of Illinois at Chicago, whose work on sickle cell disease treatment had been nominated for a National Scientific Prize. Ms. Grayson was my teacher in 1966, Dr. Pollitt. Marsh said. I was 15. My family had moved from Mississippi the year before. I had never been told directly by any adult in authority that I was intelligent. Miss Grayson read an essay I wrote about birds and told me my writing showed a scientific mind. She drove me to the library on a Saturday. She wrote to the Field Museum and arranged a volunteer position for me that summer. She looked at the courtroom. I am not exaggerating when I say that encounter changed the direction of my life. The research I've done has contributed to treatments improving thousands of patients' lives. That achievement has a root. That root is a teacher in room 214 who noticed something in a 15-year-old girl that the girl couldn't yet see in herself. The courtroom was completely quiet. Daniel did not cross-examine. Judge Obi called a 45-minute recess at 11:40 a.m. Daniel splashed cold water on his face in the men's room, looking at himself in the mirror. He had all the law. Every statute, every precedent, every correct citation, none of that had changed. But he had sat in a courtroom for 2 hours and listened to 5 witnesses describe a life lived entirely in service to other lives. The accumulated weight of 54 years in a South Side classroom was not something the law in his briefcase could fully hold. He called Gerald Hartley from the hallway. How's it going? The defense has been presenting character witnesses, former students. It's extensive. Is it changing the legal picture? No, the law is still on our side. Then what's the problem? Daniel paused. I'm not sure I can articulate it cleanly. Then don't. Win the case, Daniel. You have the law, use it. He hung up, sat on a bench in the corridor, opened his briefcase to pull out his notes for the recess, and something fell out. A photocopy he hadn't put there deliberately, a document that had been tucked inside the original case file when it was handed to him and that he'd never looked at because he hadn't needed to. It was a letter. Dated March 12, 1987, addressed to the City of Chicago Department of Housing. Signed by Estelle Mae Grayson. She had written it herself, by hand, then typed. Responding to a previous eviction notice, 37 years ago, a different owner, the same building, same apartment. The letter was 3 pages long. It was not a plea, it was an argument. Precise, legally aware, structurally sound. She had cited relevant statutes, identified procedural defects in the notice she'd been served, and made a clear case for why the eviction was legally deficient. And at the end, after the legal arguments, she had written 1 paragraph that was something else entirely. I am a teacher. I have taught at DuSable High School for 25 years. My students walk past this building on their way to school. They see my window. Some of them have been in this apartment when they had nowhere else to go. This address is not simply where I sleep. It is part of the geography of their lives, the landmark that tells them a person who cared about them lives nearby. You may have the legal authority to remove me from this address, but I want you to understand what you would also be removing and from whom before you exercise that authority. The city had dropped the eviction in 1987. No explanation on record. They had simply withdrawn the filing. Daniel read the letter twice, then a 3rd time. He thought about Mrs. Calloway, 6th grade, Milford Elementary School, Ohio. She had kept him after class and told him his essay on the American Revolution was the best she'd read from. A student in 10 years. He was 11. He had no father who talked about his future. He had no mother who had time to, between the two jobs. He had a teacher who said one true sentence about what he was capable of, and that sentence had quietly restructured everything that came after. He had not thought about Mrs. Calloway in nearly 20 years. He thought about her now. In a courthouse hallway in Chicago, with Estelle Grayson's 1987 letter in his hands, he thought about Mrs. Calloway and understood something that he had spent a very long time being too busy to understand. He had climbed the ladder, yes, but someone had first told him the ladder was there. He sat in the hallway for the remainder of the recess. He was not thinking about the law. He was thinking about what the law was for. When the recess ended, Daniel did not return to the plaintiff's table immediately. He walked to where Renata Cross was gathering her notes in the corridor. Ms. Cross. She looked up. "I'm going to recommend that my client settle," he said. "Lifetime tenancy, current rent, standard inflation adjustments. I wanted you to know before I go back in." Renata Cross studied him for a long moment. "What changed?" "I read something." He didn't elaborate. "Some things didn't need translation. I don't know if my client will agree. They'll probably fire me." "Probably," she agreed. "But I'm going to recommend it." She nodded once. "I'll be ready for whatever happens." Daniel walked back into the courtroom. Judge Obie had returned to the bench. Daniel stood before he was called on. "Your Honor, I have a statement." Judge Obie raised an eyebrow. "Go ahead." "On behalf of the plaintiff, I am recommending to my client that we withdraw the eviction complaint and offer Ms. Grayson a lifetime tenancy agreement at her current rent with annual cost of living adjustments. I believe this is the right resolution, and I am formally communicating that recommendation now on the record." The gallery stirred, not with applause, with something quieter, the sound of collective breath released. Daniel's phone buzzed in his jacket pocket, then buzzed again, then rang. He silenced it. Judge Obie looked at him. "Does your client concur with this recommendation?" "I don't yet know, Your Honor. I am making it on the record so that my recommendation cannot later be disputed." The phone rang again. Daniel took it out, looked at the screen. Gerald Hartley. He declined the call. It rang a third time before he had pocketed the phone. He turned the phone off. "I see," Judge Obie said. He looked at Renata Cross. "Miss Cross, how does the defense respond?" "The defense accepts the terms as proposed, Your Honor, and requests the court formalize any agreement." "In that case," Judge Obie said, "I will note the plaintiff's recommendation on the record and set a mediation date to formalize terms." He paused. "Regardless of whether the client ultimately concurs, I want to address the legal question before this court because it has implications beyond this case." He looked out at the gallery. "Illinois law is clear. The plaintiff has the right to terminate this tenancy. I cannot, strictly speaking, deny that right on the basis of the defendant's character or community contributions. The law does not contain that provision." He paused. "What the law does contain is equitable discretion. And equity requires a court to see not just the letter of what is being asked, but the full human weight of what a ruling will accomplish. I have heard testimony today about a life spent building other lives. I have heard about a woman who showed up consistently across 54 years for children who needed someone to show up. That is not legally cognizable in most contexts, but it is real, it is consequential, and it is part of what this court is looking at when it considers the equities of forcing a 100-year-old woman from the apartment she has called home since 1962. He set down his pen. I am not denying the plaintiff's legal rights. I am ordering the parties to mediation, and I am noting clearly in this record that equity strongly favors settlement. This court is adjourned. Daniel walked out of the building into the cold November air. His phone, when he turned it back on, had 11 missed calls from Gerald Hartley and a text that read, "You are terminated effective immediately. Personal items will be boxed. Do not return to the office today." He stood on the courthouse steps and read the text twice. Then he put the phone in his pocket and stood in the cold air for a while, watching taxis move on the street below, watching a woman push a stroller past the courthouse entrance, watching Chicago go about its business without knowing that the 100-year-old teacher was, at this moment, still in her apartment. He thought about what he had lost. He thought about what he had not. 3 weeks passed. Daniel filed for his bar insurance, set up a bare-bones solo practice from a borrowed desk in a Wicker Park friend's office, and took on 3 underpaying cases: a Pilsen, family fighting, a no-cause eviction, a small business owner with a fraudulently terminated lease, a Rogers Park woman being forced out of a rent-controlled unit by a landlord who cut her heat in October. On a Tuesday in the 4th week, he received a call from Alderman Curtis Webb. "Mr. Ashford, I want to talk to you about something we've been organizing." "All right." Several of us, former students of Ms. Z.C. Ben Grayson's, have been discussing the need for a community housing advocacy position. Someone with real estate law expertise who works on behalf of tenants facing displacement, particularly elderly and long-term residents in neighborhoods under development pressure. We've secured seed funding. It's a director-level position. It's yours if you want it. Daniel was quiet for a moment. "Why me?" "Because you turned off your phone in a courtroom," Webb said, "when your managing partner was calling. You made a recommendation your client hadn't authorized, on the record, knowing what it would cost you. That tells me something. It tells you I'm unemployed. It tells me you're the kind of lawyer we need." The salary was $85,000, less than a quarter of what Hartley, Crane and Voss had paid. The office was a shared space in a Bronzeville community center, 4 blocks from Estelle's building. On his first morning, Daniel walked past the Langston on his way in. He looked up at the 3rd floor, 4th window from the left. The light was on. He visited Estelle on a Saturday, 2 weeks after he started the new job, not as an attorney, just as a person who owed her something he was still learning to name. She answered the door in the same careful way, fully dressed, completely composed, as though visitors at any hour were events worth being prepared for. "Mr. Ashford," she said, "come in." They sat the same way as before, sofa, wingback chair, the weight of all those framed pieces of student work watching from the walls. "I wanted to thank you," he said, "for the question you asked me." "Which question?" "Who taught me?" She nodded slowly. "Did you answer it?" "Not to you, but to myself, yes." He paused. "Her name was Mrs. Calloway, 6th grade, Milford Elementary, Ohio. She told me I was capable of something important when I was 11 years old and had no particular reason to believe it." Estelle looked at him with the steady attention of a woman who had spent 54 years listening to what people said and what they meant. What happened to her? She died 3 years ago. He had found out by searching her name after the hearing. A brief obituary in an Ohio county paper. Retired teacher, beloved by her community. Survived by 2 children and 7 grandchildren. No mention of Daniel Ashford, because why would there be? He had never called, never written, never found a way back to that classroom to say, "You said one true thing to me when I was 11 and I have been living inside it ever since." I never told her what that meant, he said. I didn't know how to find my way back to it until your apartment. Estelle was quiet for a moment. Then she said, that's the hardest thing about teaching. You plant things and you rarely see them grow. You just have to believe in the planting. How did you do it for 54 years? Never knowing which ones took root. She smiled, and it was the smile of someone who has thought very carefully about a question for a very long time. I didn't think about which ones. I thought about the student in front of me. Every child is a door, Mr. Ashford. You either open it or you leave it closed. I decided a long time ago that I would always try to open it. Not because I knew what was on the other side, because every closed door is a loss, and I couldn't bear to be the one who left it shut. Daniel sat with that. Every child is a door. He thought about the 41 names on his list: judges, aldermen, scientists, firefighters, public defenders, lives that had passed through Estelle Grayson's classroom and emerged with something planted inside them that had grown into cities, into institutions, into thousands of other lives downstream. He thought about what he had almost done, how close he had come to, serving as the mechanism that removed this woman from the place where all of that had started, legally, correctly, completely. The mediation is scheduled for next week, he said. I'm told Meridian's new council is prepared to offer lifetime tenancy terms. So, I've heard, Estelle said. You'll stay. I will stay, she said simply. Daniel looked at the walls of student work around him, all those names, all those years marked in Estelle's careful handwriting. He thought about what Mrs. Calloway's classroom might have looked like, whether she had kept things, whether there were walls somewhere in Ohio covered in sixth grade essays from children who had gone on to become whoever they became. He thought about a sentence that had restructured his life without him knowing it until now. This is the best essay I've read from a student in 10 years. One sentence, one teacher, one door opened for an 11-year-old boy in Milford, Ohio, who had gone on to climb a ladder he had always attributed entirely to himself. Thank you, he said again, and this time it carried more weight than the first time because now he knew what he was thanking her for. Don't thank me, Estelle said. Go open some doors. He walked back through Bronzeville in the cold November air, past the Langston with its carved stone lintel and its third-floor window with the light on, past the community bulletin board he could picture without seeing it, past the street where children walked to school every morning, with the knowledge that somewhere in a building nearby, someone had lived for 62 years for the sole purpose of making sure they mattered. He had 3 new case files waiting on his desk at the community center. A family in Pilsen, a woman in Rogers Park, a small business owner in Austin whose landlord had decided their lease meant something different than what it said. People the system had already decided weren't worth the effort. He walked faster. He had doors to open.